Hello, and thank you for joining us on the Ask Andrew show today. My name is Andrew Feldstein, the Andrew and Ask Andrew, and I'm the principal of Feldstein Family Law Group. We have offices in Markham, Oakville, and Mississauga. And today, our special guest is Colleen O'Brien. She's an employability specialist and president of Practical Solutions. Let's begin. Colleen, thank you for joining us today. I'd like to get started, and we have some questions for you. And I may interrupt some of the flow of the show if we get some questions coming in on the Facebook Live feed or in other social media. But I understand that Practical Solutions, your company offers services related to career transitioning. Sorry, wrong question on my list. I wanted to find out the employability assessment during a divorce. How often do you deal with that?
That's probably the bulk of what I do in my career and with my company.
Okay, what type of assessments do you get involved in? Do you do it for both sides? Can you explain what your role is in doing an assessment?
Well, my philosophy with Practical Solutions is fairness, and the employability assessment helps determine more fair spousal support. The focus of the employability assessment predominantly is on the non-earner in the family, where there's a spouse who hasn't worked for a period of time, either all of the marriage or part of the marriage. And then we do the assessment to help determine what they might be able to do if they were to return to the work environment, and also to what they could potentially earn when they're able to work or return to work.
Okay, so for the viewers to understand, it sounds like what your role is to try and give an opinion as to the dollars that the recipient spouse could earn, because that's an important piece of the puzzle in trying to determine spousal support, both going at the current time and going forward. So I'm also wondering, who usually would hire you? Would it be the payor wants you to be involved to comment on the recipient's ability to earn income, or would it be the recipient hiring you to say, look, I don't have the ability to make much money?
Actually, you're right on both counts. Predominantly, it is the payor, and it's usually the situation where he doesn't want to have to pay additional spousal support, or he's concerned about how much spousal support he or she may have to pay. And they believe or feel that their ex-spouse can return to the work environment and earn a substantial living. So they will hire me to do the assessment to determine what is their employability potential, what kind of work can they do, and if they're able to return to the work environment, what could they expect to earn? The other piece of that is also a spouse where her ex-spouse or current spouse may be what we call an under-earner. He or she may have purposefully gone and got a job earning less money than they may have previous in order to not have to pay spousal support. So then I would do an assessment to determine that they may actually be an under-earner at this point. And then the third piece to that is an individual who knows that they need and want to be able to go back into the work environment, but they don't know where to start. They don't know what they can do. It's been many years. Their education may not be at what they feel it could have been or should be at this point. So they'll ask me to do an assessment with them to determine where do they start and where do they go.
Okay, now do you often get hired by both spouses to do it as a joint retainer?
I've had a couple of questions about that, but I have never done that at this point. I think that would be very ideal to do it in that case.
Okay, so one of the things that I think about in this scenario is the recipient spouse is reluctant, because most of the time the recipient spouse is saying, I can't work, I'm not able to work, or if I can, I don't earn much money. And then they're coming to you because the payor spouse has forced them to come to you, in essence, through a court order or otherwise, to say they can earn money. I would wonder, how cooperative would that person be? Because I would think they're trying to put their worst foot forward for you.
Yes, sometimes that's the case. But usually my role in that is to be able to gather a lot of background information from them and just kind of get a sense from them, what is it that, they can do? What do they feel they could do and should do? And there are some individuals who feel very strongly that they cannot return to the work environment. That part of it doesn't always enter into it because, again, depending on who's hired me, if it's a payer hiring me, the goal is to be able to determine what could they do. Oftentimes I've found that their reluctance shifts once we've been able to determine that they in fact can go back into the work environment and potentially earn a substantial living and have some financial independence. I've noticed that there's a bit of a shift in them because usually their reluctance is based out of fear. They're very afraid because they haven't worked for many years. So it's like, I don't know what to do now. And I don't feel that I can work. My skills are outdated or for whatever reason. So I found sometimes there, as I said, there's a shift.
Okay, so walk me through it. If I have one of my clients, and let's say I'm acting for the payor as the example, and I either ask or I get a court order for the recipient spouse to come and see you, what happens at that point? How do you start the process?
Usually it starts with a basic interview, getting background information, where they went to school, what kind of work did they do, trying to get a whole full history from them. And then it's very important for me to get their perspective on what they would see their barriers are. And oftentimes they would say their barriers are no skills, outdated skills, there's no work in that field that they used to work in, that sort of thing. And then often I will do testing with them. So I do a series of aptitude, interest testing, ability testing to really be able to get a full picture from what they're telling me, what their past experience was, and then to get current data from testing with them. And then I compile all of that information, and then I do a cross comparison and matching with realistic occupations that match all of that picture that I've been able to gather from them. And then I put the report together. And then I also will include recommendations in it because I feel that's equally important for the non-earner to be able to have a sense of what steps can they take in order to be able to transition into the work environment, whether it's job search assistance, whether it's possibly some retraining or refreshing in a certain career.
So if one of my clients was talking about this and they wanted to hire you, one of the questions I'm always going to hear is, what's the cost?
All of my services are flat rated, unless I have to attend court and things like that, then it's an hourly rate. But for an employability assessment, it's $1,800 plus HST, of course. So that includes all of the research, includes the testing, the interviewing.
And have you testified in court?
Yes, I have.
And how receptive has the court been to the evidence you're giving in a family law case in terms of the person's employability?
Well, I can give you an example of one particular case where the non-earning spouse wanted approximately $70,000 a year in spousal support. And we were able to show that she, in fact, was able to earn a very substantial living if she goes back into the work environment with very little additional training. And so after I testified, it's my understanding from what I've been told that the court decision was that they reduced the spousal support from 70 to 40 for 1 year, allowing that individual to get the potential refreshing that they needed, and then to go on to get a job.
Well, that sounds like a great result. Certainly worth the $1,800.
Yes.
Certainly worth $1,800 and some hourly rate.
I like to think so, yes.
So why I wanted to give that type of illustration is perfect for our viewers to see the advantage of using your kind of service, because if you are in that typical engagement of what income there is, the court very often jumps to minimum wage.
Yes, you're right.
If I have a 50-year-old that says, I haven't worked in 20 years, I find most of the time the court will simply say, what's the minimum wage? And the arguments you get into sometimes is, well, that doesn't mean that it's always going to be minimum wage, and it doesn't mean the person isn't going to grow. And what are they going to do to grow their income? So there's more to it, in my opinion, than just jumping in at minimum wage, and there's a real value that can be provided in your service. Yes. Now, I did see that we have a question that came in on one of our social media venues, and it's from Jenny. And she says, my husband lives on his own, lies on his income tax return and claims $40,000 a year. I know he makes $250,000. How do I get the support that is rightly owed to me? That sounds like, because he's self-employed, I don't know that this is one that's as great for someone like Colleen, in part because it may not be based on his educational skills or job experience. This is based on what he's able to earn as an entrepreneur from the business he's creating. And $250,000 as an entrepreneur, unless he had some really great credentials, is more than he's probably going to earn anywhere as a T4 employee. Would I be right in that assumption, Colleen?
Yes, I think so.
So what you're looking for isn't the vocational assessment with him. It's trying to find the evidence that shows he makes $250,000 a year. And this can be an expensive process of looking into it. Now, this can involve lawyers, or most likely will involve lawyers, may involve some experts with respect to income, who are chartered accountants and chartered business valuators. And when you look at it, you're trying to look at the lifestyle. You know, I always remember I had a case where someone claims he makes $50,000 a year, but he lives in a 6,000 square foot home, drives an Aston Martin. You can look at that and you know right away he's not making $50,000. He didn't pay $160,000 for a new car on a $50,000 salary. But the challenge is, you've proven in that scenario the man isn't telling the truth. But now what evidence do we have to get to his income? So that's where the expert comes in and says, let's see his lifestyle. How much does he spend? What does he need to earn in order to support that kind of lifestyle? We also will try and look at credit applications. So when we look at his financial statement and we see he has debts, lines of credit, mortgage, well, when he applied for that $750,000 mortgage on his $3 million home, what did he disclose was his income? These are all things that we work at, and we look into various issues. But there's a lot of work involved in that process, and it's not inexpensive. To the person who asked that question, I would suggest you give our office a call and you ask for a free consultation. If you want it with me, that's great, and I'd be happy to have a chat with you. I see we have another question. Is an employability assessment considered an expert report? And I think that's a great question. And I'll ask Colleen, when you've given evidence, have you been qualified as an expert?
Yes, I have on several occasions. So yes, it is. To answer that question, it is considered an expert report.
And I would say that if it wasn't an expert report, I don't see any judge accepting that kind of evidence. I've had cases before where we've talked about getting expert reports for a specific industry because someone has been, say, a controller for the last 20 years. So we've gone to the recruiters who just do the type of positions like controllers, and we try to ask them, what's the salary range for a controller, which I think is slightly different than what Colleen does, because Colleen is about finding where the person should go to work, not based on where they have been working. Am I right about that, Colleen?
You're right on both counts again. We usually take a look at where the individual has been working and then sometimes compare that to where they are working now to look at sort of the salary ranges and increases and what would someone 10 years ago make and what would they be making in the same field. So there's the work that I do really does cross a variety of avenues in that respect.
Okay, so the example I was giving of a controller is usually the controller just got let go from a job.
Right.
And now they're looking for another job and they may accepted one, and we're saying your income is too low. There's a lot of work out there that you could have found at a higher pay. And that could be, and I think of the one as a controller because I've seen that over and over and over again. And part of it will be geography related. I mean, one of the questions clients often ask me would be, especially when things were booming in Calgary, well, I could make 50,000 more if I moved to Calgary. Do I have to move? And my answer has always been no. The court doesn't expect you to move across the country to make more money. So there's different interesting issues that can come up. And I think you got to really be thinking of somebody like Colleen Services. It's about someone who, A, is intentionally underemployed. I look at that as a change in industry. And should they have changed in industry, and B, someone returning? Here's another question. Is an employability assessment the same as an income assessment? I would say it's not, because us family law lawyers, when we deal with income assessments, That's when we hire the chartered accountant, chartered business valuator to go in and look at a business owner's business and their tax returns and write a report that says, this is what they actually make. You know, one of the biggest differences between being self-employed and being a T4 employee is that if you ask a T4 employee what their income is, they're going to be able to say, well, my salary is X. Ask someone who's self-employed what their income is, and they don't necessarily know the answer until they finish their final meeting with their accountant and the year-end statement is done. And even then, I find a lot of self-employed people don't know their income. So it's a different kind of question. I had another question, the one I started with earlier. Was I understand that Practical Solutions offers services related to career transitioning as well. Are these entirely separate services, or do they often follow the employability assessments?
They can, again, be both. If someone, for example, if there is a spouse who recognizes that they need and want to get back into the work environment, they may have had a career previous, and they're just not sure what direction to take. They need to kind of look at where do their skills fit now, that sort of thing. So that would be just strictly a career transition service, career exploration, we tend to call it. And being able to help them get back on that path of, excuse me, their career goal path. And then help connect them to different areas in whether it be job search to get back into the work environment. It can follow an employability or be combined with an employability assessment. Again, if an individual, for example, may have started out prior to their marriage, may more in a minimum wage job, and they really don't know what to do. They know they need to go back to work, but they haven't got a clue as to what to do. So then we will do the employability with the testing piece, the aptitude and interest testing that I referred to earlier, and then we would move from there into the career transit. Once we've identified some realistic occupations, then we can move them into the career transition service piece if that's what they want to be able to do and help them get back.
Well, one of the interesting things I think from that is when you act for the support recipient, you can try and use your services that you just described almost like a shield to being able to get an income, because you could say, I went to you, I tried to learn where to go, and the opportunities are really limited. And look, here's the expert saying I'm not going to do better than minimum wage. So
that happens, yes.
Okay. Now I see we got another question, which is, how does maternity leave affect my employability?
I don't think it would really affect your employability because maternity leave is usually time limited. And once someone's been on maternity leave or once it's completed, they usually tend to go back to work.
I tend to think it should be entirely irrelevant, except that it plays into family law for your arguably for quantum of support. Once you've returned to work, if it impacted your career, you may say you want some compensatory support as a result of it. But for the most part, you continue on with your career.
Exactly.
My next question is from the lawyer's perspective. What is a good indication that you and your clients may need to consult an employability specialist such as yourself?
The best situation, which I've always, when I talk to both lawyers and to clients directly who contacted me, is the best time to look at whether you need to do an employability assessment is right at the beginning of the divorce process or the separation process. It really has a lot of benefits if you do it at that point. Usually what I tell lawyers that I work with is when you have a client come into the office, if they answer no to these two questions, are you or your spouse working? And are you or your spouse planning on going back to work? If the answer is no to those questions, then I say, I think you need to have them or you need to consult an employability specialist such as myself to determine where you need to go from that point. As I said, the benefit if you do it early, if the individual needs to be able to return to the work environment, it allows them time because it takes time to be able to prepare to go back to work if you haven't worked for several years. So it allows them that. It also provides a better sense of, I think, fairness and ability for the couples to be able to negotiate. And sometimes it can even avoid having to go to court on that particular issue. And instead of, as you said earlier, having the court decide, it allows the couples to be able to maybe negotiate.
Well, the interesting thing that I find with most courts is they seem to give the person who's been out of the workforce for a number of years about a year or two to figure out what they need to do if the family can afford that. And I mean, that's what I see the courts doing. And I think what you're also suggesting is if you did that at the beginning, you may be getting that person who's a recipient on track much quicker to getting a job than giving them a year or two of figuring it out, shall we say.
Exactly. Yes, it gives them a template to work with, because I usually try to write it all out in a business plan so they've got something step by step to be able to work with.
Okay. And when there has been resistance for the employability assessment to be done, what are some of the more significant forms of resistance that you've seen?
I've had some spouses refuse to meet with me, to refuse to talk with me, refuse to do any testing with me. And in cases like that, I can actually do an assessment without actually meeting the client. It's not ideal, but it does work. And I've had positive outcome from that as well. So as long as I can get sufficient information from the payer or from any documents that are achieved from that, say your client will give to you, that has information regarding their background, their education, employment history, that sort of thing, and even demonstrated that they have tried to get work, and then I can take all of that information and I can still do an assessment. And
have you ever been involved in cases when there's a court order for you to be involved?
Yes, I've had a few cases where they have been court ordered for me to do an assessment. The client is much more resistant at that point because they feel forced into it. But again, I try to be as open and honest with the clients and to share with them that this is to give them information as well, even though from their perspective, they're forced into it, but it will give them information that they can use for themselves.
And have you had situations when it's been court ordered and they still didn't show up?
Yes, I've had a couple of cases where they've had that happen. And I think they're still figuring that one out.
Well, those become the more colorful cases that as lawyers, you usually remember the ones where people do things that are really bizarre. And one of the bizarre things is usually when people violate court orders that you remember. So let me go on to my next question for you. It's possible that when people hear the words career transition, they think of it as a step back or starting from scratch. After going through a divorce, it might be discouraging of thinking of starting over with a new aspect of your life. What advice do you give people faced with these challenges?
Yeah, usually clients who have to go back into the work environment, they are pretty discouraged initially. And they're frustrated and they're confused, which when I meet with them, the first thing I always tell them is that that's normal. And to be confused is a good thing, which usually gets kind of a strange reaction from them. But my feeling is that if you're confused, you have options. If you're not confused, usually there's not many options there for you. So you individuals who have that tendency of frustration and confusion, it usually means that they have some options. So we tend to try to really work with them on that. The other thing I try to get them to really understand is that transition is a part of life. We all have many, many transitions in our lives in many ways. So I get them to try to take a look at that and to be able to look at various transitions that they've had in their life and to just take one step at a time. First step's kind of the toughest, and usually things get a little easier from there.
I have found the information you've provided for today's show to be really informative. I know I've learned a lot because I can't remember a case where a vocational assessment was actually done in my career, and I don't see many lawyers doing it. I'm certainly going to be thinking about you and this type of assessment in the future, and I hope my viewers would as well. So I really appreciate you coming on and educating all of us.
Thank you very much. It was a pleasure.
Pleasure having you. Now, we're going to have a new segment on the Ask Andrew show, and this is an opportunity for me to give some thoughts on a particular issue with respect to family law. And today we're going to have a discussion about what do you do when you disagree with your family law lawyer. Okay, so what do you do when you disagree with your family law lawyer? That's the question. And this is something that happens all too often. I give an opinion, my client disagrees with me. Now, I look at them in different levels because certain types of disagreements are going to be fine. So, for example, I tell a client, I think they're making a deal. I think they can do better, and they want to make a deal anyways. And if I think the deal is a little bit bad or a little bit unfair, I'm going to go along with representing them and make sure that the deal follows their instructions, because at the end of the day, the instructions come from the client. It's the lawyer's job to educate the client. And in that kind of scenario, I'm going to warn them it's a bad deal. I'm going to ask them to sign an acknowledgement that it's a bad deal. But I understand if somebody wants to make a deal that where they're paying an extra 20, 30, 40,000 more than they should because they want family peace, they want to get along better with their ex, they think it's going to be better for their kids, which it may very well be at the end of the day. I understand that. But then there's a different scenario. There's the scenario where a client comes into my office and they're a client of mine and they want to do a really, really, really bad deal. So picture the case of someone who didn't work in 25 years and their spouse makes $300,000 a year and they want this deal so badly that they're going to say, I don't need any spousal support. I just want my child support and I just want my share of the house, but I don't need any spousal support. And you're looking at them and saying, you don't even know how much money you can make. You may only make $30,000 a year. And the child support and your income won't be enough. This makes no sense. Now, that's a very different situation because as a lawyer, I have to sign a certificate of independent legal advice that says certain things, such as you did it voluntarily, you did it with no coercion, you did it with no duress, and ultimately it looks as if the agreement is fair and reasonable. And if that happens, where this agreement is really one-sided and I don't feel comfortable with it, I know I just said the client gives instructions and the lawyer follows instructions, but as a lawyer, I have a choice and I can say, you know what? I am not going to be a party to this deal. I am not going to sign the certificate of independent legal advice because you are doing such a bad deal here. I'm not comfortable with it. I want no part of it. And that happens and happens more often than you think. And when it does happen, we say to the client, we're sorry, we just can't do this. Now, what does that client do? That client may find another lawyer who will go and sign the independent legal advice certificate, or they may struggle to find any lawyer who's willing to participate in that. So when we look at that, that becomes a real concern because we don't want people signing bad deals. Then there's the last form that I see, and this one is more difficult because this is when the lawyer and the client are really at loggerheads. Because one of the things you see in family law, you should get the client who says, I don't care what it's going to cost me. I want you to get blood from my ex. I'll pay you any amount of money. I am so angry. I am so furious with them. I want to punish them and I want you to do everything you can. And you give that client advice and they don't want to listen to your advice at all. They just want you to do exactly what they say. And you sit there as a lawyer and you say, I have an ethical duty to tell you where we should go with your case and give you recommendations. And it's one thing when we have a discussion and you want to make a little bit of a bad deal, like I said before, or I may say to you, we can bring this motion. I'm not sure it's going to be successful. It's a maybe. That's one thing. But I'm not prepared when we have a case where you're telling me to do things that I know are surefire losers and are just wrong because A, you're throwing your money down the drain and paying for me. B, you're going to end up paying costs to the other side. C, the litigation optics for you are absolutely awful because the first thing a judge does whenever they touch a case is they usually read what the other judges have written about the case before, because there's a section in your court file called the endorsements that shows what every judge has written. And when you're taking unreasonable positions, the judges are going to say it in their endorsement. It may be in a way that if you're not a lawyer, you're not going to appreciate it, but other judges will. And that negative optics will detrimentally affect your case going forward. And I'll say to you, I'm not prepared to take these steps. And when that happens, you, the client, have a choice to make. You can take my advice or you can take your business elsewhere. But when you're doing things that are really don't make any sense, we're going to tell you that. And those are the kind of disagreements we usually see. And ultimately, the client, as I said, I gave you 3 examples. In the first example, we'll follow the client's instructions. In the other 2, we won't. And in that case, it's going to be incumbent on the lawyer to either A, listen to the lawyer's advice, or B, part ways with the lawyer. And they may find the same problem with other lawyers, or lastly, find a lawyer who will do what they say. Those are my comments on this issue, and thank you for joining me. Okay, next Ask Andrew show will be on June 21st at 1 o'clock. If you have any questions for future shows, then please email us at info@feldsteinfamilylaw.com or tweet us at Andrew Feldstein, and we'll be happy to put your questions on the next show. And thank you for joining me, and